from GRS Community Management, I'd like to introduce, and for some of you, reintroduce Courtney Buchan. Courtney, take it away. You might be muted, my friend.
Sorry, technical difficulties. Hi, guys. Good afternoon. Thank you so much for joining us today for today's webinar on elections, community association elections, presented by Peter Mollengarden over at Kaye Bender Rembaum. Thank you so much, Peter, for doing today's presentation. So a little bit about GRS before we get started. GRS is a leading local property management company in South Florida, Lake Worth to be exact. We manage over 200 communities across all counties, not all counties, but many counties, the East Coast and West Coast of South Florida. We've been providing great, reliable service since 1989. You can follow us on LinkedIn, Instagram, X, formerly known as Twitter, and Facebook.
I'm still not calling it X. I refuse.
I know it's a little difficult, right? I had to think about that one. If you would like to learn more about our services or job opportunities, please visit us at grsmgt.com. I'm very excited about today's webinar because, I think for most of us, we are in the prominent election season for our communities. Very important items to go over. I know it's a stressful time for everyone involved. Whether you're a board member or you're a manager, there's a lot that goes into these board elections. So today's presenter is Peter Mollengarden. He is a board certified specialist in condominium and plan development law. As Jeff had told me before the webinar started, there's not that many board certified specialists in condominium plan development law. So that good going on that, Peter. That's great. Been serving and practicing law since 1984, and he works out of the Kaye Bender Rembaum Palm Beach Gardens office. So today he's going to be going over everything elections for condos, homeowners associations, and co-ops. So without further ado, Pete, take it away.
Okay. Thank you, Courtney, and good afternoon, everyone. As Courtney mentioned, we are entering season, and although season for everywhere includes trees and menorahs and tinsel and decorations and turkeys and more traffic for us down here and more crowded restaurants, we also have election season. So for condominiums, cooperatives, and HOAs, typically when we move into the winter and early spring, mostly during the winter, we have our elections. So today's presentation, we're going to focus on some of the ins and outs of elections for both condos, co-ops, and HOAs, because it's a general survey type course, although it is pretty specific. Obviously, I can't cover every single tiny aspect of what's going on. So I always encourage everyone when I do these presentations or when I do my radio show, which I do every week on Monday morning from 9:05 to 10, you always have to consult, with your documents, with your attorneys and things like that for the specifics. So without further ado, as they say, we'll start. Now, because I am technically challenged, among other things, the slides are going to be controlled by Jeff Solomon. By the way, thank you, Jeff, also. I'm going to leave you out. So Jeff's going to do the slide thing, and I'm going to do the speech thing, and hopefully it'll all work out. So let's go. Elections, condos, cooperatives, and HOAs. And you can go to the next slide, Jeff, if you're listening. All right. And a little cartoon, and we can skip.
Yeah, hang on. You're not the only one who's temporarily tech challenged you. Okay, I'm ready. Go ahead.
All right. Stay awake with me. Stay with me. All right. Number of directors. And this is for condominiums and cooperatives, as it is different for them than with respect to HOAs. Now, typically your documents will provide, what the size of your board is, whether your board is, 5 or 7 or 9. But oftentimes, especially with older bylaws for condos and co-ops, you'll have a provision which might say a range. Let's say it might say not less than 3 nor more than 7. or not less than 3 nor more than 9 or something like that. In that instance, if it has that type of range, but it doesn't have a way to determine the number within the range, that is what we call a valid method, then under these statutes, chapter 718, the board will default to 5 because it's 5 members unless otherwise provided by the documents. And there's a couple of cases on this where the bylaws said, for example, that the number is not less than 3 nor more than 7 as determined at the annual meeting. Well, in condominium and co-op land, you cannot determine the size of the board at the annual meeting because as we're going to discuss very soon, everyone votes ahead of time by ballot. So you can't determine the number of directors at the meeting. So in those bylaws, it will default to 5 under the statute. And what are the terms of the directors? Your time is expired. Your term is expired. Okay. For condos and co-ops, the terms of all the board members will expire at the annual meeting. Okay. And the members may stand for re-election unless prohibited by the bylaws, which means that your bylaws could provide for term limits. Because they said that your term expires or doesn't expire at the annual meeting. Now, if it's a timeshare or a non-residential, that's something else. If you have staggered terms, obviously, then your staggered terms usually mean that all the directors are serving either 2 or 3 year terms on a staggered basis. Obviously, in that context, then the term doesn't expire at the annual meeting. It will expire at the annual meeting when that multiple year term is up. Now, if all the directors' terms would otherwise expire, but there are no candidates, then the terms will not expire because the board will roll over, okay, in that particular instance. Now, if permitted by your bylaws or your articles of incorporation, board members may serve a longer than a 1 year term. So again, some documents do provide for staggered multiple year terms. Usually they're staggered. They could be multiple year terms, not staggered, but typically multiple year terms are staggered. Now, as of July 1st in 2018, a condominium board member may not serve more than 8 consecutive years, right, unless approved by 2/3 of the members voting in the election. Not 2/3 of all the members, but 2/3 of those who voted in the election, or there are not enough people willing to serve on the board. So if not enough people willing to fill the vacancies, then you can go beyond the 8 years. Now, again, the 8 years also commenced July 1st, 2018. It's not retroactive to before that time. So we're still in that 8 year period. So it is a term limit, but it's a term limit that has an exception or has 2 exceptions. Like I said, if you get more than 2/3 of the vote, so those people can actually run. So if, a couple of years from now, a few years from now, someone has served 8 years, they could still run. And if they got 2/3 of the vote, then they would be elected. Or if there weren't enough people willing to serve, then there are vacancies, they could also serve. Now, if you have the same or fewer number of candidates as there are vacancies, that's known as election by acclamation, and they're automatically elected. Again, condominium and cooperative. There is an acclamation also for HOAs, and we'll get to that in a few minutes. Are you eligible? Lucky you. Well, you may be, or you might not be. So let's find out. Okay. A candidate means an eligible person who has timely submitted their written notice. Again, this is for condominiums and co-ops, their written notice of their intent to become a candidate. Any owner desiring to be a candidate for the board must be eligible to be a candidate to serve at the time of the deadline for submitting their notice of intent to run. Now, that deadline is no later than 40 days prior to the annual meeting where the election will take place in order to have your name listed on the ballot or to serve on the board. So again, there's a difference between eligibility to be a candidate and eligibility to serve. Eligibility to be a candidate means not necessarily, by the way, that you have to be an owner. It's a misconception or a myth that by law it says that condo board members, co-op board members must be unit owners. Unit owners are eligible to be on the board unless they're felons or something like that, and we'll explain that in a minute. But if the documents are silent or the documents don't limit the board members to being unit owners, then anyone 18 years of age or older who's a resident of the state could theoretically run for the board. So again, there's no automatic owner-only provision to serve on the board. That must be something that's established by your governing documents. Okay, as I just mentioned, because I'm ahead of myself, the governing documents may require that the board members be owners. Under Chapter 617, by the way, what is Chapter 617 besides a number? Chapter 617 is the Florida Corporation Not-for-Profit Act, okay, which you do have to check out sometimes because that will, since almost every corporation that is an association is a not-for-profit corporation under Chapter 617, 617 does apply to certain situations. In this situation, it does expressly provide that if a unit is owned by a trust, the grantor of the trust or the beneficiary of the trust who resides in the unit are eligible to serve on the board. The trustee of the trust is also eligible as the trustee is actually the legal owner of the unit. So just keep that in mind. Next one, Jeffrey. Thank you. Okay. Another cute little picture about board eligibility. All right. Now this is pretty important. As of July 1, a couple of years ago, 2021, a person who was delinquent in the payment of any assessment due to the association is not eligible to be candidate. Now, this is your delinquent in the payment of assessment as of that deadline to submit your name, okay, which is not less than 40 days before the meeting, before the election meeting. So even if you become current the next day, you're not eligible because the deadline for eligibility is the deadline to submit your notice of intent. Now, this law used to say, or this statute used to say that it's all monetary obligations. If you're delinquent in any monetary obligation, which would include a fine or other things like that. But again, it was changed a couple of years ago to be delinquent in an assessment.
Hey, Peter, there's a question from Joe. Does the unit owner running or candidate need to be a U.S. citizen? We have a lot of international folks living in our condos and HOA. So does that matter typically?
No.
Okay.
Nope. They pay assessments like everybody else.
Understood.
And they're owners. Board member eligibility. We're going to continue on this topic. Now, certain people are not eligible, okay? Even if they are an owner. So anyone who's been convicted of a felony or has been convicted of any offense in another state, which would be considered a felony if committed in Florida, is not eligible for board membership unless their civil rights have been restored for at least 5 years as of the date they seek election to the board. A person who has been suspended or removed by the Division of Florida Condominiums, Timeshares, and Mobile Homes, is also not eligible. Now, in a residential condo, not a commercial, in a residential condominium of more than 10 units, or in one that does not have timeshares, co-owners of a unit may not serve as members of the board at the same time unless they own more than one unit, or again, there is not enough eligible candidates to fill the vacancies at the time of the vacancy. Now, this is a relatively new law. I mean, it doesn't go back to that long. I remember years ago when I used to ask this question, people used to say, Peter, but how can a husband and wife who own a unit together serve on the board together? That's not right. That's not fair. They own one unit, yet they get 2 votes on the board. And before this statute was changed, the answer was they absolutely could serve on the board together because they were both owners. But then again, the law was amended or changed to say that co-owners, again, whether it's spouses, brothers, sisters, 2 unrelated people, whatever, co-owners, if you have more than 10 units, they can't serve on the board simultaneously unless they own more than one unit or there's not enough people to fill the vacancies. The last bullet point is something we just mentioned again, and here it is again about the term limit of the 8 consecutive years. Again, unless the candidate, the person who has the 8 years, more than 8 years, is elected by more than 2/3 of the votes, okay, or 2/3 of the votes, 2/3 or more, or there's not enough eligible candidates for the vacancies. Okay. Any other eligibility requirements for board members are not valid. For example, and I just got this question yesterday, not by any plan that I was doing this today, but just by coincidence. A client called and said, or sent me an email, can we amend our documents to say that you have to be an owner and you have to be a resident? In other words, you have to live there. We don't want these non-resident owners, investor owners, whatever you want to call them, being on the board. And the answer is, although I've seen that in some documents, it is not enforceable. Okay, you cannot limit a non-resident owner from serving on the board, or not prohibit them from serving on the board. What? Okay, it's a serious issue. Why is it serious? Well, it is pretty serious if you have ineligible candidates that are on the ballot. In other words, let's say you do have a restriction that all candidates must be owners, okay? And you have a non-owner on the ballot, or the person was delinquent as of the last day to turn in their ballot. The last day to turn in their intent to be a candidate. So if the person, or a person, or more than one, is on that ballot who is not eligible, then you must, okay, if there's time, you have to mail out, transmit, or deliver an amended second notice of the meeting, which will explain the need for why you have to amend the notice and amend the ballot. Now, the second notice must go out at least 14 days before the annual meeting. So again, whether or not you can do this depends whether you have enough time to do the amended ballot, the amended notice and the amended ballot. If you don't have time, if you can't mail it out or transmit it timely, then you have to renotice and reschedule the election, starting with the second notice. If you already did your election and oops, we find out that there was an ineligible person that was on that ballot, then the election is void and you have to do it over again. Again, starting with the second notice without the ineligible people on the ballot. The graveyard of past, it's good for Halloween. Well, we just passed Halloween, but there's some little ghosts or skeletons in there. And these deadlines, in all seriousness, are important. Okay, in fact, they're very, very important. And again, we're still in the condominium co-op land. Not less than 60 days before the election, you must mail, deliver, or transmit, electronically transmit, and we'll get to that in a second, to the owners or to the members, a first notice of the date of the election meeting. Typically, that's with the annual meeting, almost always, but the first notice must contain the name, mailing address, and disclose, if applicable, the deadline to consent to electronic voting if the board has authorized online electronic voting. We'll get to that in a few minutes. If you don't have electronic voting, then that's not something you have to worry about. If you do, that process and deadline must be on your first notice. Now, any owner, and we mentioned this before, but it's worth saying again, any owner or other eligible person, again, because there could be people other than owners who are eligible, desiring to be a candidate for the board must give written notice to the association not less than 40 days before the election, before the scheduled election. Now, it's the owner's burden to prove delivery of that notice of intent. So the owner must ensure proof of delivery, not the association. When it's hand delivered, okay, the association is required to give the person a receipt. If it's not hand delivered, the association is not required to furnish a receipt. This is why the division, the division of condominiums, timeshares, and mobile homes, the division actually, by the rules, encourages owners to either, or candidates, other eligible candidates, to either hand deliver their notice of intent to be a candidate to the association, in which case they must get a receipt, or to send it by certified mail, return receipt requested, in which they'll get the receipt that way. And I'll just mention quickly, there's a couple of cases out there, these are old cases, where in one case, the owner swore up and down that he slid his notice of intent under the manager's door and on the 40th day at 11:58 p.m. right? So before that magic clock struck 12 and turned into a pumpkin. But the arbitrator held that because he, or in this case, I think it was a he, could not prove that he actually delivered it timely, he wasn't allowed to run. There was another one, I think, where they claimed they tacked it on the door at 11:58 or whatever. That also was disavowed. So again, the burden is on the owner. I'm going to emphasize this again, is on the owner to prove, or the other eligible person to prove that they delivered that notice of intent to be a candidate timely. Again, so either do it by hand delivery or certified mail. Okay, enough about that. Now, upon the request of a candidate, again, this is optional. This is not mandatory. Upon the request of a candidate, the association must include an information sheet. Some people call them resumes or whatever other names, but the technical name is information sheet. An information sheet about themselves, no larger than 8.5 by 11. Now that must be furnished if they are going to give it or furnish it. It must be furnished by the candidate not less than 35 days before the election. Now this must be included with your second mailing, okay, with the second notice of the ballot, with the cost of the mailing, delivery, or the transmission to be borne by the association. Now it's not on the script here, but I go off script occasionally. But these information sheets, the owner or the candidate, other eligible candidate, they can write pretty much whatever they want on these information sheets. The association cannot modify them, change them, alter them. Now they still have to be within that 8.5 by 11 piece of paper, but the association cannot edit these things. And invariably, it seems like every year, not this year, actually not last year either, I get a call or two from a client saying, hey, Peter, you know what? We got this information sheet from this guy or this woman, and man, we can't put this in there. I mean, they just said all sorts of awful things about the board, about the manager. Yeah, they called us all poopy heads. They called my sister a poopy head. It's horrible. It's terrible. And I go, like, you know what? That's on them. You can't edit it. You can't change it. You have to include it. Because what the law also says, and it's not here, but I'll just mention it, if the information sheets, assuming you're having an election, if the information sheets of the eligible candidates are not included, every one of them, then that election will be most likely voided and deemed no good, and you have to do it again because you failed to include all the information sheets, again, that were timely delivered. Okay. Now, not less than 14 days, we already did our first notice, right? And the first notice went out, and we got the information, and we got the candidate forms, the intents to run, we got the information sheets. Great. Now, not less than 14 days before the election, annual meeting and the election, together with written notice and the agenda, you have to mail, deliver, or electronically transmit the second notice. Okay. And the second notice will include the ballot. The ballot must list all the candidates alphabetically by surname, okay, or last name. And the ballot cannot indicate, it's not on the slide, but I'll tell you, it cannot indicate who's an incumbent or who's not an incumbent. None of these voting materials can say anything for or against any candidate. Have to be completely neutral. So it's just the ballot with the candidates listed alphabetically by their last name. Now, this notice, in addition to being sent to all the owners by mail, delivery, or electronic transmission, excuse me, must also be posted conspicuously on the condominium property at least 14 days before the meeting. Now, your notice could be longer if your governing documents require it to be a longer notice. However, by law, the notice cannot go out any more than 34 days before the meeting, because there's that 5-day window between the 40th and the 35th day when owners can submit their notice of intent, their information sheets. So you have to give that 5-day window from the 40th day to the 35th day for owners to submit their information sheets. So you can't send the annual meeting notice. So it's really between 34 and 14 days, depending on what your bylaws say, but not less than 14 days before the annual meeting. And if your bylaws say 30, then do it 30, at least 30. Okay.
And Courtney, before Peter gets to the next slide, in the Q&A, feel free to chime in if there's a follow-up question that somebody asks of Peter. So, because some of them might be timely based on what he's speaking about at that point in time. If that's cool with you, we don't have to wait to the end for all of them because we may not remember what the question was about.
Questions? Where's my billing pad? No, just kidding. Just kidding.
Told you he was funny.
Just kidding. All right. Website notice. For condominiums with 150 or more units, as hopefully you are aware, you must have a website. Okay. Now, if you're one of these associations that's required to have a website, then the notice of your annual meeting and the agenda must be posted on the website no later than 14 days before the meeting. Has to be on plain view on the front page or on a separate subpage labeled notices, which is conspicuously visible and linked from the front page. You're also required to post on the website any document to be considered and voted on by the owners during the meeting. For example, you may be voting on, I don't know, something else at that annual meeting, or at your member meeting, and any other document listed on the agenda. And that has to be posted at least 7 days before the meeting at which the information or the document is going to be considered. All right, electronic notice. We've mentioned this a few times. Now, this means electronic notice is not electronic voting. Electronic notice is either email or facsimile. I know facsimile is kind of a dinosaur, I guess, these days, if anyone still does it, but that's part of electronic notice. Owners who consent to receiving their meeting notices by electronic notice, and they have to consent in writing, then you can send the notice of the meetings to them electronically via the email or the facsimile or however they decided. However, with the second notice, the fact that it has 2 envelopes and a ballot, and we'll get to that in a second, I always encourage my clients to do that by old-fashioned, hard copy, just because of the nature of that. Obviously, if it's electronic voting, that's different. Now, electronic notice cannot be used for recalling board members or for voting to opt out of the retrofit for the fire sprinkler system. Any address provided by an owner to fulfill the notice requirement is subject to inspection by owners. So this is important, because if an owner has consented to receive their meeting notices by email or by facsimile, then that email address or that facsimile number, that is their official address, okay, under the official records of the association. And that is now accessible to any other owner who wants to inspect it or get a copy of it. Otherwise, email addresses are privileged and are not accessible by other owners. Again, they are accessible if an owner has agreed in writing that is their address for their notices from the association. An owner, if he or she wants, can always revoke in writing that permission to use the email as their address. And in that case, it is no longer accessible to other owners. A quorum. Look at that meeting. Okay. This is important, and most of you probably are aware of this, but it's worth mentioning. It's really worth mentioning. For condominiums cooperatives, there is no quorum requirement to conduct an election. However, at least 20% of the eligible voters must cast a ballot in order to have a valid election. So if you want to call that a quorum requirement, you can, specific just to an election, okay? But just be advised that if normally you need a majority, for example, to have a meeting of the membership to establish a quorum, for an election, you do not. For an election, you only need 20% of the eligible voters casting a ballot. Please be reminded that if the association owns any units that they acquired, let's say through foreclosure or otherwise, they don't get to vote those units, and those units don't count toward a quorum anyway. So they don't vote units that they own. Now, while an election can be conducted under that 20% rule, okay, if there's other business to be conducted at that meeting, for example, if you're voting on an amendment to your documents, if you're voting on a material alteration, if you're voting on, let's say, whether to waive reserves. We won't get into the SIRS reserves today. But if you're doing votes other than the election, those issues, you will need a quorum in order for the owners to address those things. So the lack of requirement to have a quorum for the election does not apply to other business that you may want to conduct. And at the bottom there, very, very important, and we'll get to that in 1 second, condos and co-ops, you cannot vote by proxy in an election. It has to be by ballot. And that ballot must be submitted either by hand or by mail or by carrier pigeon or Pony Express or however you're going to get it there, but no proxy voting. This person looks like a happy condo person, right? Oh, there she goes. See how happy she looks? Anyway, verifying outer envelopes. Okay, this is pretty crucial. At your annual meeting, at your annual/election meeting, the first item on the agenda actually is the election, okay? Because you can do the election without having, like I mentioned before, a quorum. So the first thing you're going to do is you collect any ballots that have not yet been cast, and you actually make that announcement because you're supposed to have blank inner and outer envelopes, blank ballots and inner and outer envelopes at the meeting for anyone who's voting in person, as opposed to, having it mailed or hand delivered beforehand. Now, once an election ballot is received, it cannot be rescinded. It cannot be changed. All right. So once you got your little hands on it, the owner cannot rescind it, cannot change it. Now, you are required to verify or check in, or whatever words you want to use, these ballot envelopes. Now, that is done by the election committee. Okay. This impartial committee. This impartial committee is appointed by the board, and it cannot be any current board members, any officers, or any candidate for the board, or any of their spouses. These people cannot serve on this committee. What does this committee do? This committee basically checks in those outer envelopes to make sure they were signed by the owner, all right, by the proper owner who has the authority to vote for that unit, and it has the unit number on there. Now, they can do this either at the annual meeting in front of everyone, because everything that the committee does must be in the presence of the owners that are in attendance, or the association can notice in the same manner that they notice for a board meeting, 48-hour posted notice that the committee is going to meet earlier in the day on the same day. So if the meeting's in the afternoon, before that, if it's in the evening, before that, they can do this verification ahead of time on that day with again, this committee, as long as it's posted properly, date, time, and place of this meeting. Now, they still have to verify any other ballots that are turned in at the meeting itself, at the election meeting, but they can check in the other ones. Now, at this meeting, or either beforehand or at the annual meeting itself, they're going to check the signature and the number, the unit number on the outer envelope against a list of qualified voters. And then they check off the ones that they accept, and they're checked off on the list as having voted. Any outer envelope not signed by the eligible voter is marked disregarded, which they write on the outside of the second envelope, the outer envelope, and they put those aside. They do not open those outer envelopes, the ones they mark disregarded. They just mark them disregarded. They put them to the side. They keep them, but they're not opened. All right. All right, we did that one. As I mentioned before, everything is done in the presence of the owner. So if they've checked in all the outer envelopes, right, we're all ready to go. All right. Once they've done that, then they open up the outer envelopes and they remove the inner envelopes from the outer envelopes, and they put them in a receptacle, or supposedly. Now, once they start opening those envelopes, by the way, that by law closes the polls. That closes the polls, and no more votes can be counted or submitted once they start opening these envelopes, and no more ballots can be accepted. So then, after they've separated the inners from the outers, sounds like belly buttons, right? But it's not. Once they separated the inners from the outers, then they open up the inner envelopes, take out the ballots, and they count. It's done by a plurality. In other words, who gets the most votes? They get a majority of votes. Who gets, it's just who gets the most votes. Now, if an inner envelope contains more than one ballot and the person only owns one unit, well, no good. Okay. That's marked disregarded, and those are put to the side. By the way, I'll say this because people ask me all the time. If you're electing 5 directors, right? And let's say there's 7 candidates, you can vote for up to 5. You don't have to vote for 5. If you want to vote for just 1 or 2, or less than 5, that's okay. You cannot vote for more than 5, because that would be not okay. So if you've marked your ballot for 6 and you're only electing 5, that's no good. But if you're only interested in voting for 1 person or 2 people, or 2 candidates, that's okay. Some people call that bullet voting, whatever. Okay. Next, if we have a tie, all right, what happens? So if 2 or more candidates for the same position receive the same number of votes, which would result in one of them, okay, not serving, or serving a lesser time. In other words, if you're doing like a stagger type vote, then the association shall, unless your bylaws provide otherwise, conduct a runoff election. That means within 7 days of the day of the election at which the tie vote occurred, the board must mail or personally deliver to the voters, the owners, a notice of a runoff election. The only people in the runoff election are those candidates who tied. So they're the only ones that are on this runoff ballot. Let's just be those candidates who tied. The notice must inform the voters of the date of the runoff election, and it must include a ballot, like I said, which includes copies of the information sheets. Remember the information sheets we talked about before? Well, for these candidates that are in the runoff, you have to include their information sheets in this runoff election package. And finally, that runoff election must be held not less than 21 nor more than 30 days after the date of the election when the tie occurred. Okay, now we're moving into HOAs, out of condos. HOAs, by the way, completely different than the condominium cooperative procedure. In an HOA, the governing documents may require that board members be lot owners. By the way, the HOA law also says that all members of the association are eligible unless they're felons or things like that. And we'll talk about that in a second. Terms are provided, term of office are provided in the governing documents. There's no maximum term or term limit. Similar to condos, though, if you've been convicted of a felony, okay, or any other offense in another state, which would be considered a felony if done in Florida, committed in Florida, you're not eligible unless your civil rights have been restored for 5 years. Now, a person who is delinquent in the payment of any monetary obligation due to the association, now when is that? That is that time period, or that is done is if you're delinquent in any monetary obligation as of the last day when you could have put yourself into nomination or been placed into nomination, then you're not eligible. Now, when is that last day when you could be in nomination? That depends upon your documents. All right. Now, contrary to the HOA, contrary to the Condominium Act, if you recall from a few minutes ago, said if you're delinquent in any assessment. Now, for reasons that just makes my life more difficult and your life more difficult, the legislature says for HOAs, though, it's any monetary obligation rather than any assessment. So if you're delinquent in a fine or something like that in an HOA, you're not eligible. But if you're delinquent in a fine in a condo, you are still eligible, because for condos, as you may recall, it's only if you're delinquent in assessments. Now, unlike condominiums, co-owners are permitted to be candidates and serve on the board in a homeowner association. And those are the only eligibility requirements that we have. Okay. Here's something new. It was just passed effective October last month, actually. An officer or director charged by information or indictment with forgery of a ballot envelope or a voting certificate, theft or embezzlement, or refusal to allow access to official records in furtherance of any crime, or been charged with obstruction of justice, again, not convicted of these things, just indicted or arrested, charged, they're not eligible. Not eligible to serve on the board. If a criminal charge is pending against an officer or director, any of those criminal charges, they also may not be appointed or elected to a position as an officer or director of any association, and may not have access to the official records of the association, except pursuant to a court order. However, the charges are resolved. In other words, if they're dismissed without a finding of guilt, then the officer or director may be reinstated for the remainder of their term, if any. Annual member meetings for homeowner associations. Similar to condos, you must hold an annual meeting of the members, the transaction of any business pursuant to the bylaws. The election of directors, if one is required, must be held at or in conjunction with the annual meeting, or as provided in the documents. All notices of annual meetings must have the date, time, and place. If your bylaws don't have a process or a procedure for providing the notice to the members, then you have to deliver the notice, again, mail, deliver, or electronically transmit them to all the owners at least 14 days prior to the meeting. Some older bylaws might be silent. So if they're silent, it's a 14-day notice. In my opinion, if they have a longer period than that, then follow the longer period. If it says 30 days, do the 30 days. If it's a shorter period, arguably you can use a shorter period, but I advise my clients to provide at least 14-day notice. And again, if a document say 30, you have to do the 30. Similar to what I mentioned for condominiums, the electronic notice or the electronic transmission, again, is only for those owners who have agreed, consented in writing to receive their notices in that manner. You still need to post a notice too. So you have to send out the notice 14 days and post it 14 days in advance. And you have to have an affidavit by the person providing it on behalf of the association that it was sent out properly. For condos, you also need that affidavit of mailing as well and posting. Now, the association, may, by rule, adopt a procedure for conspicuously posting and broadcasting notice on a closed circuit cable TV system. It has to be done in a manner that is that allows for enough time to allow the average reader to observe the notice and read it. But this is in addition to the other notice, not in lieu of, it's in addition to. And you have to keep your affidavit among your official records. Okay. Now why does this look like we're having a nuclear attack here with this big bright warning and everything like that? The election of directors must be done in accordance with your bylaws for an HOA. In a condominium, it's all statutory. So the 60-day requirement, the 40-day requirement, the 14-day notice, second notice requirement, all that is statutory or pursuant to the administrative code, which has the regulations. In a condo, though, you got to go by your bylaws for what is your election procedure. And I see so often that for whatever reason, an association will assume that they do their elections just like a condo. And they'll have a notice of intent to be a candidate, and they'll do a first notice, and they'll do a second notice. But it's not called for by the documents. If your documents, your bylaws don't include that as a procedure, that is not the election procedure. Okay, the election procedure is pursuant to your bylaws. Okay, so we'll go back one, Jeff. If the election process as set forth in your documents allows candidates to be nominated in advance of the meeting, then the association is not required to allow nominations from the floor. Otherwise, you have to have nominations from the floor. What does that mean? If your bylaws have a pre-nomination process, let's say similar to the condo process, where owners are allowed to submit themselves into nomination ahead of time. If there is this pre-nomination process when you can nominate yourself, then you don't have to have nominations from the floor at the meeting. However, if you don't have that process in your documents, not just made up, but in your documents, then you do have to have nominations from the floor for the election. Okay. Quorum. Bathroom humor, apparently. Okay. Quorum. As we mentioned a little bit ago, for condos, there is no quorum requirement. Not so fast, though, with homeowner associations. In a homeowner association, again, unless your bylaws have a different procedure, okay, you have to establish a quorum in order to conduct an election and any other business of the association. So for an HOA, you have to have that quorum unless you have an election process that provides otherwise. Now, if you have a pre-nomination process, like we just mentioned, and you have the same or fewer number of candidates that are running, so let's say you have a 5-person board, HOA, you have a pre-nomination process, and you have 5 or fewer candidates, in that instance, you do not need a quorum for an HOA election because you had a pre-nomination process, you only had the same or fewer number of candidates, so no quorum is required. So that is the exception for a quorum requirement for an HOA election. Now, what's a quorum? For a homeowner association under Chapter 720, which is the Homeowner Association Act, unless your documents or your bylaws have a lower number or a lower percentage, 30% of the total voting interest must be represented for a quorum. So it's 30% or less. You don't have to have no quorum means that there is a holdover board that only serves until the next election. So let's say you don't have a quorum, so you can't have the election. Then your board will hold over not for 3 years, but just until the next election. Okay. Election day, ta-da. Remember I mentioned for condos, you cannot vote by proxy for an election. In a homeowner association, you have the right to vote in person or by proxy unless otherwise provided in the documents. So for a homeowner association, it's all document driven, like I mentioned before, and whether or not you can vote in the election or otherwise, but whether you can vote in the election by proxy depends upon the documents. If it's silent, you can. If it only has a condo style in there, then you follow that. If the governing documents permit voting by secret ballot for those who are not in attendance, and again, this must again be set forth in the documents. I know I'm saying that a lot, but it's important, so it's worth repeating. So if the governing documents permit voting by secret ballot for those who are not attending the meeting in person, then the ballot, similar to a condo ballot, has to go in a blank inner envelope with no markings on it other than say ballot, and it must be mailed or delivered to the association in an outer envelope, which has the name of the owner, the lot address, or the lot number, and the signature of the owner casting the ballot. And then, all the ballots and proxies will be, tabulated at the annual meeting. The Bill of Rights, and it's not the Bill of Rights we're thinking of, but it's this new Bill of Rights effective, again, this past month in 7/20. This Bill of Rights is to stop, I guess, what was perceived to be inappropriate, wrong, bad, whatever word you want to use, conduct relative to elections. I want to read through this relatively quickly, but each of these acts, and this is new, each of these acts is a fraudulent voting activity related to association elections and constitute a misdemeanor of the first degree. So, what are they? Willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to or affirm an oath or affirmation in connection with an or arising out of voting activities. Perpetrating or attempting to perpetrate or aiding in the perpetration of fraud in connection with a vote cast, to be cast, or attempted to be cast. Preventing a member from voting or preventing a member from voting as he or she intended by fraudulently changing or attempting to change a ballot envelope, vote, or voting certificate. Menacing, threatening, or using bribery, or any other corruption to attempt directly or indirectly to influence, deceive, or deter a member when the member is voting. Giving or promising, directly or indirectly, anything of value to another member with the intent to buy the vote of that member or another member, or to corruptly influence that member or another member in casting his or her vote. This subsection does not apply, or that right there, to any food served which is to be consumed at an election rally or at a meeting, or to any item or nominal value which is used as an advertisement, like a campaign message, like a button or something like that. So you can't buy people's votes in that last number 5, or excuse me, in 5. And finally, number 6, using or threatening to use directly or indirectly force, violence, or intimidate, or by intimidation or any tactic of coercion or intimidation to induce or compel a member to vote or refrain from voting. Unfortunately, you wouldn't think these things are really, necessary to be codified in the law, but unfortunately they are. I hope you don't have to deal with any of this kind of conduct or behavior, but just be aware this is this new Bill of Rights with respect to voting in homeowner associations. The polls have now closed. We mentioned before that polls close in a condo when you start opening those outer envelopes. In an HOA, it doesn't expressly say when the polls close. There's nothing by statute. So the polls will close when the chairman of the meeting announces the polls are closed, after they've gathered all the ballots. Okay, vacancies. And these are vacancies that are occurring between meetings. So if you have a vacancy on the board, that's not occurring because of the expiration of a term of office. So let's say that's either by death, resignation, disqualification from serving on the board, something like that. Unless otherwise provided in the bylaws, any vacancy occurring before the expiration of a term may be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors are less than a quorum, or even if there's only one or sole remaining director. In the alternative, the board can opt out or opt to, hold an election to fill the vacancy. Typically, they will appoint. Again, so they have the authority to appoint unless the bylaws provide otherwise. And furthermore, unless otherwise provided by the bylaws, someone who is appointed or elected to such a vacancy fills the vacancy for the unexpired term of the seat being filled. Again, unless otherwise provided by the bylaws. So if you have multi-year terms and someone dies or resigns, let's say in their first year, and it's a 3-year term, unless the bylaws provide otherwise, the person who's appointed is appointed or elected to fulfill the balance of that 3-year term. Now, some bylaws do say that in this situation, the person filling the vacancy only fills until the next election or the next annual meeting. So in that case, that would control. So you have to check out your bylaws, read your bylaws to figure out, if there's any difference between the authority of the board to appoint and the balance of the term of the appointed person. If it's a recall, the filling of the vacancies is separate. There's a separate statute regarding filling recall vacancies that this doesn't apply to.
Peter, if you have a glass of water, now's the time. I just want to make a quick announcement. I failed to mention earlier, I'm battling a bad cough, so I'm trying to do not too much speaking here, but we're going to get to as many questions as we can. There's no way we're going to get to all of them. We've already got like 40 something of them in there. We have a lot of material in about an hour and 10 to 15 minutes to cover. So we'll get to a few of the questions. I know Courtney's answered a few that don't require an attorney's answer.
Well, you want them to email them to us or something? Or
yeah, you can also put them into the evaluation at the end, which I'll go over again a little bit later. But we'll get to a couple of them at the end. No way we'll get to all of them. But and when you do type in your question, be careful not to make it too specific to your association. We don't know your documents. None of this should be considered as legal advice either. Excuse me. It's for informational and educational purposes only. And when you do type in a question, try to keep it general, but in addition, don't just put in, hey, does this also apply to condos? Because if we address that question at the end and you typed in, does this also apply to condos 25 minutes ago, we're not going to know what that question is about. So be specific with your question about what the topic was, but not ultra specific to your association because we don't know your documents. Hope that all makes sense. Fighting off the coughing. Back to you, Peter. I need the water as well.
Thank you,
okay.
Jeff.
That sounds like my radio disclaimer that I do on my show. We don't have your documents, so.
Yeah, it's I tell you, I'm not an
general.
attorney, but I do so many of these with y'all. Sometimes I feel like it.
Play one on TV or something like that. Okay, or you stayed at a Holiday Inn Express or whatever. Okay, so not that I'm plugging that place, but anyway. So we mentioned the filling the vacancies. So we'll pop to the next slide. Remote meetings or remote, we know from what we just went through a few years, for seems like forever. With the pandemic, everyone started doing meetings like we're doing right here, right? Zoom and things like that. Just want to remind you all that to do a Zoom only or remote only meeting, the statutes really only allow that, okay, during a time when the governor has declared an emergency for the county in which your condominium or association happens to be located. And even then, it depends what kind of emergency it is as to whether or not, the Zoom is still appropriate. For example, if there's no appropriate physical location due to governmental guidelines, in other words, government guidelines has everything shut down, you can't gather, okay, where it is a serious matter of common interest to unit owners, including vulnerable demographics. In other words, because of the age of the people, things like that, where it's not appropriate or proper to meet together, you do it by Zoom. Or you most likely you'll provide the Zoom as an option. So if you can't, if it's not such that you have to go complete remote because you don't have a place to meet or because of pandemic situations or things like that, where it's not safe to gather, then we have the option to provide it by Zoom or by remote. I'm not plugging Zoom today either. Under 617-0721, I want you to be aware that let's say you want to provide your owners with a Zoom option, pandemic, no pandemic, not Zoom only, but Zoom option or remote option. Then you do have to follow the guidelines of 617-0721. And what this says is if authorized by the board and subject to guidelines and procedures the board may adopt, as in adopt at a board meeting, members and proxy holders who are not physically present may, by means of remote, participate in the meeting, be deemed to be present in person and voting if the association, or in this case, the corporation, implements reasonable means to verify that each person deemed present and authorized to vote by means of remote is a member. So you have to be able to authenticate and verify that those attending remotely are actually authorized to attend and vote. and you implement reasonable measures to provide such members or proxy holders with a reasonable opportunity to participate in the meeting and to vote on matters submitted to the members, including an opportunity to communicate and to read or hear the proceedings of the meeting substantially concurrent with the proceedings. If any member or proxy holder votes or takes other action by means of remote communication, a record of that member's participation to the meeting must be maintained by the corporation. And 1601 is actually the official record section of the Not-for-Profit Corporation Act. So it's not easy, really, to have remote meetings with remote membership meetings, a little different than board meetings because owners don't vote at board meetings. But if you're going to have a membership meeting and you want to do it remotely, you have to follow these procedures in order, quite frankly, those votes and things like that to count. So personally, I still like the old-fashioned in-person vote by proxy, limited proxy, or general proxy, depending upon whether you're an HOA or a condo. But there is a remote option. It's just difficult, in my opinion, to comply. Okay. And then we have some best practices if you're going to do it remotely. Don't have any surprises. You have to disclose how to register and how to participate. You should probably most likely limit your agenda because it's difficult, to do a large agenda remotely. Encourage people to ask their questions in advance. Remember, this is an option. So for those in person, you still will need ballots and proxy forms at the location for those attending in person. Remember, for condos, you must open the ballots in person, okay, in the presence of those in person. So just, a few little tips. Electronic voting. I think this might be the last topic, but let's, we mentioned electronic voting a couple times. Electronic voting basically is online voting. So I have some associations that love it. They think it's the greatest thing since voting. Anyway, and how do you accomplish that? Well, you can use an online voting system for all votes, whether it's an election or otherwise, provided an owner gives written consent to online voting, which is valid until the owner opts out, because the owner has to have the ability to opt out every time there's a vote to opt out of online and do it in person or by proxy, depending on what the vote is. An owner, not for elections, obviously for condos. An owner voting electronically is counted at being present or attendance at the meeting for purposes of determining quorum. Now, how do you establish that we're going to do online voting? How does the association establish that? Well, it must be established by the board, by a board resolution at a meeting. The notice of that board meeting must be provided 14 days prior to the meeting by mail, delivery, or electronic transmission and posted. So it's a 14-day notice sent to the owners and posted on the property that your board's going to consider adopting online or electronic voting. Okay. And the person providing that notice must sign an affidavit that that notice was properly given. Now, the board resolution at that meeting must provide that owners will receive notice of the opportunity to vote through an online voting system and must establish reasonable procedures and deadlines for owners to provide their written consent to the online voting and establish reasonable procedures and deadlines for owners to opt out. So like I said, you have to have an opportunity to opt out of the online voting. If it's used, then each owner must be provided with a method to authenticate the owner's identity, a method that is consistent with the association's election process and its bylaws or procedures, a method to confirm at least 14 days before the voting deadline that the owner's electronic device can successfully communicate with the online voting system. And the association must use an online system that is able to do the following things: authenticate the owner's identity, authenticate the validity of each electronic vote to ensure that the vote is not altered in transit, transmit a receipt to each owner who casts a vote online, and permanently separate any authentication or identifying information from the electronic election ballot, rendering it impossible to tie an election ballot to a specific owner. Because remember, particularly with condominiums, all the election votes is secret, right? Because you have that 2-envelope system. So the electronic voting system must also be able to assure that secrecy. And finally, the system must be able to store and keep electronic votes accessible to elected officials for recount, inspection, and review purposes. Now, I know that all sounds very complicated, but the software providers or the system providers they have stuff, and I'm sure the people at GRS and, Courtney can tell you about this, that they had, you can buy the system. They set it up for you. It's right. From what I understand, I've never physically done it because I don't live in a condominium, but from my own clients that have it, they indicate it's pretty simple to use. You get a lot more people participating, at least theoretically, with the online system. Again, I'm not here pushing online. I don't have any stock in any online voting companies or stuff like that. I don't have a lot of clients that do it, but the ones that have it seem to be pretty happy. Again, I'm not pushing it. Now, the first notice as we mentioned an hour ago, more or less, the first notice of your condominium cooperative election must disclose the procedure and deadline to consent to electronic voting. So if you have electronic voting, condominium co-op, then that first notice has to disclose the procedure and deadline to consent to it. Now, failure to file the procedures for giving that first notice means you have to do it all over again. So make sure the first notice is done properly, particularly with this electronic voting disclosure information if you're doing electronic voting. Election of officers, and Jeff, I don't have time, but you tell me if we're good. So I'm going to keep going. Unlike the election of directors.
Okay. We have 5 more minutes, 10 minutes left in the advertised time. So let's do 5 more minutes of course, and then we'll do a few minutes of a couple of questions that Courtney will pick and recite to you.
That sounds dangerous. Okay. So, officers are elected, typically immediately following the election of directors. In almost every set of bylaws I've ever read, the officers are elected by the board. Okay. And by the way, this is an open board meeting. I can't tell you how often I've gone, not so much recently, but to an election, they have the election, and all of a sudden now the new board members or the board members, they're going to elect the officers. They start walking to some room in the back and telling everybody, oh, closed meeting because we're electing officers. I'm like, what are you talking about? It's an open meeting. It should have been noticed, just like any other board meeting, quite frankly. Now, it is the only time that directors can vote by secret ballot. It's the only time that directors can vote by secret ballot. By the way, directors cannot vote by proxy, ever. And they generally cannot vote by secret ballot except for the election of officers. And also be aware, under every set of bylaws I've ever read, that even though it might say that we're electing officers to a 1-year term, it almost invariably also says, but the officers serve at the pleasure, or maybe the better term is displeasure, of the board. So typically the board, if they want, they can change officers midterm, midstream. It doesn't mean they can't take the officer off the board. The officer hat and a director hat, even though they might be worn by the same person, are 2 different hats. And the only way to get a director off the board is through recall or disqualification because they're no longer qualified to be on the board from the things we talked about before. But officers, again, if the board is displeased or for whatever reason wants to put a new president or new treasurer, new whatever, they can switch those offices around. The person stays on the board, but he or she no longer holds perhaps the office they held before. Again, I'm not encouraging you to do that. I'm just saying it's something you can do. Okay, board certification. I did one of these courses 2 nights ago. So what's board certification? Within 90 days after being elected or appointed to the board, each newly elected or appointed director must certify. There's a choice. There's 2 things they can do. They can either certify in writing within 90 days that you've read the documents and the current policies of the association, that you will work to uphold them to the best of your ability, and that you will faithfully discharge your fiduciary responsibility to the members. That takes about 10 seconds to sign that certification. Or in lieu of that, within 90 days after being elected, or within 1 year before being elected, you have satisfactorily completed the educational curriculum administered by a division-approved condominium education provider. I'm one of those, but there's many of us. And that written certification is valid and does not have to be resubmitted as long as the director serves on the board without interruption. So that certification is good for as long as you serve on the board uninterrupted. But if you go off the board and then come back on, even if it's for a day, you have to get recertified. again, the certification, I think they're worthwhile, not just because I teach them, but I think you actually learn something, which is knowledge is good, right? Where did I see that? Think in a movie, but knowledge is good. And I think it really helps to take that course and learn something, even if it's through osmosis, as opposed to just to sign. Again, that's just my 2.5, 3 cents on that. Okay.
Absolutely. And I'm going to cut you off there.
That's a good place to stop anyway. So
yeah. And I'll say, yeah.
So during most of Peter's presentation, I did answer some of the questions to the best of my ability. I am not an association attorney. Some of them were pretty standard. So let me go through. Oh, here's a good one. Can a potential intent, can they send their intent to run by email?
okay. I believe that they can, although I would recommend that they do it again by certified mail or hand delivery. You could do it by facsimile. I believe you could do it by email as well. I wouldn't recommend doing it that way though.
I agree. Yes, it can be tricky. I didn't want to answer that one because I wasn't sure. I know that it is something that people do, but it's not the best way to track it.
I mean, other lawyers may disagree with that one, quite frankly,
Yeah.
But I would not recommend it.
Here's a good one. I'm in an HOA, we have proxies, and I have seen candidates and directors who are going off being named substitute proxy holders that have been solicited. Could this be an issue of stacking on the board?
Well, substitution of proxy, let's explain what that means first so people out there. When someone gives a proxy, the proxy says that I hereby name John Smith to be my proxy holder. Okay. If there is a substitution power on there, okay, sometimes there is, sometimes there isn't. But if there's a substitution power on there, that means if John Smith, my proxy holder, if he can't attend the meeting, then he can substitute someone else to be the proxy holder. It's perfectly legal if that's what the proxy says. If you're doing an election and in HOAs, you can, unless the documents say you can't. If you're doing an election by general proxy, that in and of itself lends itself to potential, I don't say stacking of the board, but people walking in with 50 proxies and controlling the whole election. And quite frankly, that was the reason 31 years ago, because I was around back then, lucky me, that there were so many complaints in condos of shenanigans going on with proxy voting in elections and people soliciting proxies in less than nice ways, I'll say, that they eliminated proxy voting in condos and went to the ballots. So everyone voted their own vote. That's a historical story for you. In HOAs right now, unless your documents provide otherwise, that's fine. It's fine. It's legal. You can get now, if someone can claim that the proxy was gotten under, less than proper circumstances, that's really for the person to complain about who is the proxy giver, the owner. The association, basically, unless they have reason to think it's invalid, it has to accept the proxy.
There is a lot of questions regarding electronic voting. So here's a good one. Doesn't owners opt into electronic notification obligate the board and management company to communicate with them only electronically? I know the boards who say that electronic is convenient, so all they do is physically post on site. Your thoughts?
No, electronic voting is just a means of voting. Okay.
Yep.
It has nothing to do with how you're providing notice. It's just, no, you still have to, in fact, I could theoretically opt into electronic voting, but require all my notices to be sent to me a hard copy. Okay. There's no overlap between those two.
Perfect. And then there was another one, I'm probably going to botch this because I can't find it, but it was, I know it was something about is an election committee mandatory? What if there's no volunteers to count the ballots?
You got it right. I remember that question. You
Good
got
question.
it. Yeah.
It actually is mandatory. I've never had the situation where you couldn't twist 3 arms or 4 arms or 6 arms to do it. Because unfortunately, I mean, obviously no board member, officer, or candidate can do that counting. I mean, would it be if it's just absolutely nobody? You can't, browbeat some people to do it. Could then the manager do it? I don't know how that would hold up. There's no provision in the law for an option. So it's hard for me to say. I would say, if at all, try to avoid that. Try, I don't know how, don't bribe them because we can't do bribes. But I don't know, give people a cookie or something, but try to get some people to serve in that role. I don't really know what would happen. I mean, arguably, if the manager did it, and he did it in front of anyone, and he or she did it in front of everyone, would that be kosher? Depends what the division thinks, quite frankly. Hard for me to predict. I've never seen that fact pattern, so it's hard to say.
So quick follow-up to that, just a quick one. If with the election committees, is there a certain number that they have to have? Like, let's say they only get one person, would that still be okay?
Yeah, good question. That I don't know of any minimum number.
Okay. I guess one is better than none.
Yeah, I mean, there is a minimum number for fining committee and that kind of stuff.
Yeah.
There is not a minimum number on your impartial election committee. So I guess if I got a group of one, I'll take that group of one if that's all I can get.
Awesome. All right, I think that, unless you want to stay longer, but there's a lot of good questions. I will say some of them were very specific to those to their association asking. So definitely contact your association attorney. They'll have the best answer for you on many of the questions that you may have. And then, just like Jeff said, you can ask your question on that post-evaluation form.
And by the way, on that committee question, I don't think the administrative rules say 3. Okay, I could be wrong in that. I'm pretty sure it's silent on that, but that's my memory.
I haven't heard anything different either.
Okay.
I think you're right.
All right. Well, thank you, Courtney, very much.
Thank you so much, Peter. That was great. Thank you. I hope we get to do this again soon.
Thanks. Jeff, thank you too. Cough boy. So feel better.
Anytime, sir.